Mr. Bradbury, I understand that for many of the CIA's enhanced interrogation techniques, the test of their legality under current law is linked to the constitutional standard of whether it shocks the conscience, and that this may depend on the circumstances. But under the Convention Against Torture and the implementing federal torture statute, torture is absolutely barred, and that does not depend on the circumstances, and that does not depend on whether it shocks the conscience. So let's put that aside. Let's cut to the chase. The Convention and the federal torture statute define torture to be, quote, an act specifically designed to inflict severe physical or mental pain and suffering, mental pain or suffering, close quote. I fail to see how the agonizing pain of not being able to breathe as your lungs fill with water and oxygen is denied your body cannot be considered severe physical pain. And I fail to see how feeling that you are drowning and are about to die cannot be considered severe mental pain and suffering. It certainly is specifically designed, waterboarding that is, to inflict both severe mental and physical pain and suffering so that the prisoner will speak. Now, in your legal opinion, is waterboarding a violation of the federal torture statute?
Well, Mr. Chairman, as General Hayden has disclosed, our office has advised...
I'm not interested in your opinions before. I'm asking you, never mind former OLC opinions. I'm asking you the question now. Is waterboarding a violation of the federal torture statute?
I was about to answer the question, Mr. Chairman. Our office has advised the CIA, when they were proposing to use waterboarding, that the use of the procedure, subject to strict limitations and safeguards applicable to the program, was not torture, did not violate the anti-torture statute. And I think that conclusion was reasonable. I agree with that conclusion.
Given the definition I just read, how can you possibly justify that?
Well, first of all, I'm limited in what I can say about the technique itself, because...
We know what the technique is. It's been done for hundreds of years.
Well, with respect, Mr. Chairman, your description is not an accurate description of the procedure that's used by the CIA, and I think there's...
My description was a description that was given to this committee by ex-interrogation officers.
Well, there's been a lot of discussion in the public about historical examples. For example, as the Chairman referenced, from the Spanish Inquisition, cases of torture from the Philippines and committed by the Japanese during World War II. Those cases of water torture have involved the forced consumption of mass amounts of water, and often large amounts of water in the lungs. They've often involved the imposition of weight or pressure.
But your testimony is that that's not what we're talking about now.
That is not what we're talking about.
Well, then let me go to the following. You have refused, according to the New York Times, you wrote several memos on interrogation techniques in 2005. The Times said that the opinion about using a whole bunch of very intense techniques on the prisoner in combination, including waterboarding, so outraged Deputy Attorney General Comey that he told colleagues they would be ashamed if it ever came out. Now, that has piqued our curiosity. But the Attorney General said he could not give us those memos, and others repeatedly asked for on this subject because they were very sensitive. When the chairman of this committee, Mr. Conyers, reminded him that we all have top-secret clearance, the Attorney General simply repeated that he was unable to share them with us. Now, we have been shown documents on the NSA warrantless wiretapping that are code word, which I'm sure is a higher classification than your legal opinion of interrogation. So can you tell us why you won't, I mean, you're telling us that the opinions we're making about waterboarding are wrong because we don't know what waterboarding really is. Now, and therefore we can't form a judgment, you're telling us, on the legal basis or on whether it is legal because we don't know what literally, we don't know about what we're talking because you won't tell us. So can you tell us precisely what the legal authority is for withholding those documents from a committee of proper subject matter jurisdiction other than the fact that they might be embarrassing to somebody?
Well, Mr. Chairman, let me say I and the Department of Justice and the Attorney General fully recognize and respect the strong oversight interest this committee has in the work of our office.
We've seen no evidence of that.
Well, let me say that we do intend and we strive to respond to and accommodate.
Let's break through all this. Will you commit to letting us see those memos? And if not, why not?
We are giving that serious consideration. Mr. Chairman. We are giving that serious consideration.
Is there any legal basis for saying no to a committee of jurisdiction where this falls squarely in our jurisdiction and where we all have clearance, security clearance?
Well, these are matters that traditionally are subject to the extensive oversight of the intelligence committees
and the Judiciary Committee.
And the classified details of the program are very close hold for that.
Excuse me, I said we all had top security clearance. So given that fact, is there any legal justification for withholding those documents?
Well, Mr. Chairman, as you and I have discussed this very question before, the interest is the interest that the President and the executive branch has in protecting the potential public disclosure of...
Wait a minute. That's saying it's secret. We all have top security clearance. So all you're saying is that it might be revealed. We have top security clearance.
I think there was some discussion previously, perhaps mentioned earlier in the opening statements, about public disclosure. We're
not talking right now about public disclosure. We're talking about disclosure to this committee.
I understand that, and my point today is we recognize your interests. We recognize the unique nature of this issue, the controversial nature of the issue. We do recognize the extraordinary...
But you keep not answering my question. What is the legal basis for your assertion of your ability to have discretion about whether to give those documents to us?
Mr. Chairman, I'm not asserting any legal basis.
If there is no legal basis, then you must give them to us.
It's not a decision for me, but I am saying that the Attorney General, in close consultation with the President, are giving careful consideration.
Are you the head of the Office of Legal Counsel?
Yes.
Isn't it your job as such to give the opinion to the Attorney General on these kinds of questions?
We do, most often, yes, advise the Attorney General and the President on matters that potentially involve executive privilege issues.
So have you advised the Attorney General that they have the legal right to withhold these documents from this committee?
I don't know.
Or that they don't have the legal right?
Mr. Chairman, the executive branch does have the legal right to protect the confidentiality of deliberations of the executive branch and sensitive documents.
So the executive branch, you're saying, has limited right to, in its discretion, to withhold any document because of confidentiality?
I'm absolutely not saying that. The Congress has very strong constitutionally based interests in getting information necessary for oversight.
Thank you very much.
We recognize those interests, and we...
But you won't commit to giving us those documents despite the fact we have security clearance, so your recognition is totally hollow.
I will commit to attempting fully to satisfy the committee's interests in these matters to the fullest extent possible, consistent with legitimate interests that the executive branch has. And let me just underscore, we are...
Okay, let me just say then that within a few days after this committee, we'd like an explanation in writing. We'd either like to see those documents or an explanation in writing and why we can't see them and what the legal basis of your right to withhold them is.
Okay.
Thank you. I'll now recognize the distinguished ranking minority member for 5 minutes.